glad to have you here.
Likewise, happy to be here.
I would like to start with a couple of words about you and your company. So if you can just give me a big background of you and some information. How did you create the company, the law office or firm? I don't know how exactly you call it.
It's a law firm. I branched out and founded my own law firm in 2004. Previously, I'd worked at a number of law firms. I started doing patent law at the world's largest law firm, Baker & McKenzie, and then tried working at a patent boutique here in Seattle, and eventually decided that I could actually do it best on my own.
And it seems that you're doing it pretty well in the last 6-7 years.
Yeah.
Really. That's pretty good. So, are you the sole owner of the company, or?
I had partners in the past, but now I'm the sole owner of the firm, and we have 3 attorneys here, other than myself, with a new one showing up in a few weeks. She's currently meeting with our partner law firms in Beijing, and then once she's finished with that trip, she'll be joining us back here.
That's pretty good. And what is the area that you expertise in? So is it only patent law, or you also provide other services?
Well, the 10-second explanation is high-tech intellectual property law. So we do patents, we do trademarks, we do copyrights, we do trade secrets, all revolving around high-tech. We like to say we do the dry stuff. We don't do the wetware. No chemical, no biotech, but computers, software, mechanical, those types of things.
And do you work mostly with startups or also with big companies?
Our biggest clients are multi-million-dollar corporations. Our smallest ones are solo inventors.
Solo inventors.
Yeah.
That's pretty good as feedback. If people, for example, want to come to you with questions, what type of questions you'll be able to answer?
Anything relating to intellectual property. So if they have questions about how to protect their ideas, how to protect their brand, how to protect their art or creative works. So when people talk about IP, it can mean different things to different people. So an artist is trying to protect their book or their painting or their electronic art. An engineer may be talking about protecting their code or their prototypes, and a product company may be talking about their brand and their reputation and the goodwill.
Can we start digging into this, and what is the difference between, let's say, patent, copyright, and what are the other options to protect intellectual property?
So a patent protects an invention. So an invention is actually made up of 2 things. The concept, which is the idea, where it's the loose solution that you've come up with, and the reduction to practice, figuring out how you would actually accomplish that particular solution to the problem. So when we talk with our clients, we talk about answering 3 questions: why, what, and how. And why is what's the problem that was out there that was trying to be solved? What is, okay, this is the feature set of your solution to the problem. And then the how is, how do you actually accomplish that, or how do you actually build that feature set and put it together?
Okay, and that's what you protect with a patent.
That's what you protect with a patent.
What about the trademark?
So trademark is you're protecting the person's reputation. So usually you'll see that in the form of a brand or a slogan or a logo that a company or an individual uses to protect or to represent the reputation of that thing. So the very famous ones are like the Nike swoosh. Anybody sees that on a shoe and they say, immediately they have this brand association, this reputation of what these shoes are known for. And you can actually have a hierarchy of brands. So you can have Nike is one brand, and then you can have Air, which is one of their sub-brands, So you know that, oh, that's the line of shoes that uses the air cushioning.
Mhm.
And then you can have Jordan, which is the Nike Air Jordans. The Jordans are their sports shoes that use that particular branding, but it's also using some of Michael Jordan's reputation in there. He's reviewed them and endorsed them, and so it's that way of collecting all this goodwill, and it's a repository where it can be stored. And so a trademark, you actually don't need to register it to actually have a trademark, but the most powerful brands usually are registered with the federal government. And that's when you see the little circle R symbol next to a logo or a brand or a trademark.
Yeah, I was curious about that part. So what is the difference between the small circle R symbol and the TM symbol?
All right, the TM symbol is just a little symbol anybody can stick on anything.
Mm-hmm.
And it's basically they're saying aspirationally, this is a trademark, but it hasn't been reviewed by the government. And it hasn't been certified that yes, it's unique, and we think that it truly is a differentiated mark that's deserving of federal registration. Once it has a circle R, the U.S. Patent and Trademark Office has reviewed it, made sure it's not confusingly similar to other marks, and given it stamp of approval. Now, an interesting thing, trademarks can last forever, but a patent only lasts for 20 years from the date that you file it.
Mm-hmm.
And then the other one was copyright.
The copyright is the next one, yeah.
So a copyright is protecting artwork, whether it's writing or painting or something that is fixed in a tangible medium. There has to be something physical that for the copyright to apply. So if you have a play, you can't copyright the play, the performance of the play, but you can copyright the script, because there's something physical there. The play was just a performance. It's something that happens in time. There's nothing that you can point to and say, this is the physical play.
Yeah.
You can copyright the script, and somebody else who videotapes the play could copyright the videotape that they made of the play, but it wouldn't be the playwright that would get the copyright necessarily there. Then it gets a little bit more complex, because that video is a derivative work that came from the script that the playwright wrote. And so you can actually end up with two artists sharing responsibility for the copyright. And again, you don't need to have it federally registered, but by registering your copyright, you can actually end up with a much more enforceable and powerful piece of intellectual property.
And we'll dig a little bit deeper in more details, but for example, how much does it cost to, let's say, file a patent or register trademark or register copyright?
So
approximately, so that
Yeah.
can be different on the time spent and the review spent, but approximately, or range.
So a good range, and the patents are by far the most expensive, because the most effort goes into preparing a patent application. And they're actually quite powerful in that even if somebody independently comes up with your invention later on, your patent can still block them. So for the patent, a good ballpark cost or over the life of the patent is about $25,000 to $30,000. It's only about $12,000 to $15,000 to file it initially, but over the life you're going to have to argue with the patent office to actually get the patent through and then pay for it to be issued. So about $25,000 is a good ballpark.
And that takes a couple of years actually until it gets processed, right?
About 3 to 5 years is a typical range that we see in the computing space.
And that, you mean, that's actually the time you pay the money. You don't pay the money after the 5 years. So that after the patent is issued, do you pay any additional money, or?
So every 4 years after the patent issues, there's maintenance fees to keep the patent alive.
Okay.
And those maintenance fees go up in price over time.
Until that reaches the 20 years.
Until it reaches the 20 years. Then there's the trademark is less than $2,000 usually, unless you have to fight with the patent office, and then it can get more expensive. But again, less than $10,000, even in the very difficult cases.
Yeah.
And then copyright registration is less than $500. Usually we're at about less than $300 to get a copyright registered. But it's a much simpler process.
Yeah. In the technology world, are there too many copyright filings, or you're mostly seeing trademarks and patents in the technology world?
We see a lot of patent filings because there's with the creative software developers that we're often working with, if they independently come up with their own program after they've seen somebody else solve a problem, and they independently come up with their own way of solving that problem, they're not going to be violating the copyright of the person. Since to violate a copyright, you need to have opportunity to see the thing and have actually copied the code, either the object code or the source code, or been able to see the painting and then make a copy of it. I actually had an interesting situation with a client who'd made a sculpture, and then in Holland somebody else saw a sculpture that was very similar, and we looked into whether it was a copyright violation, and no, it was just two artists had come up with a very similar sculpture at the same time, and because they both independently produced it, there was no copyright violation. It was just two creative people thinking along similar lines.
Okay, that's interesting. Okay, let's wrap up this part, and I would like to dig a little bit deeper into the patent stuff later on.
Sure thing.
Okay.